through and through.
Yeah.
All right. Good afternoon, everyone. Welcome back to the Judicial Proceedings Committee. Today's Friday, March 1st, 2024. We're on voting list number 8. We're going to park our conversation from before just until we have one other member back. But we will go on to Josh. Can you read us up on Senate Bill 273?
Yep. Senate Bill 273 is a departmental bill that prohibits a person from intentionally photographing or recording images of a correctional facility through the use of an unmanned aircraft unless authorized by the managing official or the secretary. The bill also prevents a person from using an unmanned aircraft to deliver any contraband to a person detained or confined in a place of confinement. A violation of either would be a misdemeanor subject to a maximum penalty of 3 years or $1,000 fine. And correctional facilities must post signage warning of the bill's provisions on the exterior of the property. You have an amendment in your packet. It's number 543728/1 from Senator Sidnor. This somewhat rewrites the provision prohibiting the photographing or recording of images of a correctional facility. So if you turn to the reprint, the new language is on page 2 of 3 in lines 8 through 10. So it would now read, a person may not intentionally operate an unmanned aircraft over a correctional facility for the purpose of photographing or recording images of the correctional facility through the use of the unmanned aircraft without the authorization of the managing official of the correctional facility or the secretary.
Thank you very much. And this is language that I worked on with the agency that I agreed to and would ask that we move the amendment.
So I appreciate your efforts working with the agency. Second the amendment. Is everybody okay with adopting the amendment? All right. Now the bill is before you as amended. Further discussion? Motions for favorable and seconded. Is everyone okay being recorded in the affirmative? Excellent. Good work. Senate Bill 273 passes unanimously. All right. So Senate Bill 398, we're holding again just for fiscal purposes. So we're going to consult with B&T once they get the budget. We'll skip down to, do you want to go to Senator Muse? Jamie, are you ready for Senate Bill 449? We're going to wait until Senator James is back to resume that other discussion.
Senate Bill 449 alters the time which a court is required to dismiss a charge of first-degree murder or a crime considered sexually assaultive behavior against a defendant found incompetent to stand trial to the lesser of 10 years or the maximum sentence for the most serious offense charged. A victim or a victim's representative has the right to petition the court for extraordinary cause to extend the time to dismiss a charge against a defendant found incompetent to stand trial for these crimes. For a crime of violence, if the victim or the victim's representative has submitted a written request to the Maryland Department of Health for notification or submitted a victim notification request form. I do want to point out there's a technical fix that needs to be made in the bill. On the last page of the bill, there's a erroneous reference to NCRs, which is not competent to stand trial, or not criminally responsible. That shouldn't be in the bill. If you delete that text at the very end of the bill, it would not change the substance of what I just read.
All right. You can do that amendment now, though, right?
Yeah, it's just voting to strike that.
All right. Is that okay with everyone? All right. That's all right. So that's recorded.
What page?
What page is that?
That is. All right. So what I'm looking at is on page 2, line 20 to 28. that section of the code applies to NCRs instead of ISTs.
Best counsel just explained there's some opposition from the judiciary. I want to understand. Just want to make sure.
So Maryland judiciary had an issue with the bill. Primarily, they were concerned that the extension of time doesn't really account for the possibility that a defendant will never be found to or be restored to competence. That if somebody is permanently incompetent, that they should be. It should focus on civil commitment and that keeping the charges viable wasn't the way to go with this. The Office of the Public Defender also mentioned that other options exist, civil commitment exists, and because the case would be dismissed without prejudice, there's really nothing to keep the state from bringing back the charges once the defendant is, if the defendant ever becomes competent again.
Further discussion. Let's have someone. All right. Go ahead.
Favor with amendment.
It's favorable with amendment.
Okay,
Go ahead.
that was missing. I heard Jamie express concern.
The concerns that they had raised were more policy based on
Do they have a suggestion?
I
Okay.
It's been a motion for favorable. It's been seconded with amendment. Are you all, you want to do roll call? Or you want to do vote? Is everyone? All right.
Vice Chair Waldstraker,
Yes.
Senator Sidnor,
Yes.
Senator West,
Yes.
Senator Muse,
Yes.
Senator Folden,
No.
Senator James.
Yes.
Senator Charles,
Yes.
Senator Kelly,
Yes.
Senator McKay,
Yes.
Senator Carter,
Yes.
Chairman Smith.
Yes. Gonna go back to 118 and 421. We're combining the two. So we're gonna open up that discussion again. If you could just refresh where we were when we left off.
Sure. So the amendment that we had been discussing would have put the bill in the same posture as the House had put the bill during the previous session.
So Senator James had some language that she would want us to entertain. Do you want to adopt this amendment and then build off of this amendment with your language, or do you want to?
We actually haven't talked about that language. Should we?
So let's hear what this is, and then the amendment's still open, so we're gonna hear what this is.
So I think it was it John Cox in Baltimore had raised an issue where there was a concern that because the existing expungement statute provides that a new conviction that happens within 3 years would make the person ineligible for an expungement under the current law, that unless that section of law was amended to reflect that there's a greater time period here. Under this amendment, it would be 15 years. Under the bill, it would have been 10. But in any event, unless that section dealing with ineligibility was amended to account for the longer time period, you would have somebody who in year 4 after their probation before judgment could commit a new offense or get convicted of an offense and would still be eligible at the end of the time period for expungement. So his suggestion was to account for that. I would note that the amendment that was circulated earlier this morning did account for that somewhat. The House had accounted for it last year, and that's in front of you. But what wasn't accounted for was the possibility that somebody could get a probation before judgment within a 15-year period of time. So just to refresh the committee on this, state law already prohibits getting more than one PBJ for a DUI, DWI offense within 10 years. So at 10 years, you would become eligible again to get another PBJ. Because this bill would be setting it at 15, you could still have somebody getting a second PBJ at say year 11 and then still eligible for the expungement on that original PBJ after 15 years. So
though exceedingly rare, as we've heard before, and very highly improbable, still possible.
So I put together some language. You don't have it in front of you, but the language would essentially provide that in the specific context of an expungement for a PBJ for an A or B DUI, DWI offense. So there's the alcohol violations, which would be the only ones eligible under the bill. That a person would be ineligible if one, they had been convicted of a crime other than a minor traffic violation, or a crime where the act is no longer a crime, or two, received a probation before judgment for a violation, any violation under 21902 of the transportation article, which is all of the DUI, DWI offenses. So that would address both the conviction end and the PBJ end specifically for this offense. Within the 15 years, right?
Senator James.
Is what you just said pretty similar to the language that
I
the
think
attorney offered?
I had looked at John's language.
Okay.
I think, you know, just from a drafting perspective, I took a slightly different approach, but I think it addresses what he had brought up. Yeah.
Thank you.
Senator.
Thank you. I'll defer to Senator Muse here, but I think this actually makes the bill better. I think it was always the intent that if there was a reoffense during the waiting period of expungement, that the expungement would be disallowed. And I think because we switched the 10 to 15, we accidentally got into a situation. And as Senator Carter mentioned, a second PBJ for a DUI is very rare. But obviously if someone got it, they should not be eligible for expungement of the first PBJ. So I think this actually not only doesn't do any damage, it makes the bill better. So I thank you, the Senator from Hartford County.
Just one last point of clarification. So I agree with you, Senator, but just so obviously the expungement after 15 years only applies for alcohol related offenses. But if you get, let's say, driving while high or on prescription drugs or something like that, you're still gonna be, that's gonna reset this. That is applicable. Is that right? I just want to make sure that's on the record. All right. So Senator James, are you okay adopting the First Amendment before you and then your amendment afterwards? Okay. So is that easier for you? Or is that?
That's.
Yes. Okay.
So the amendment and the amendment number, Jamie, do you want to go?
Can you just read it and then we can?
So the amendment is for SB 118, Amendment 393-824/1. There was one change that Senator Muse had asked for on the amendment, which was to have the effective date start in July. So that would be incorporated as well.
Motion is to move the amendment. Seconded. Is everyone okay? Okay. All right. Sorry, Senator Folden.
I guess my question is, normally we reserve July for urgent matters.
Usually July, not so much urgent matters. July tends to it does coincide with the start of a fiscal year.
Yeah.
So
But
I'm not sure
this
what
doesn't have a note on it. So does that mess up as far as for review process with once it's passed and still, is that a achievable standard for this bill because there's no real fiscal note associated with it? So we don't have to
depends
worry
on what you achievable for who.
Just the implementation and stuff.
So for judiciary,
for the review and everybody else that
Right.
has to review it for the legality and make sure everything's done correctly.
No, it shouldn't. I mean,
Okay.
the AG reviews these before presenting to the governor and then produces a letter advising the governor on whether or not there's a recommendation
Okay.
to sign. So yeah, that shouldn't affect it.
Okay, thank you.
All right. So then now the bills before you as amended, we have Senator James's amendment. Just to refresh, can you say what it is? And then I know you don't have an amendment number, but just for everyone.
So the language would provide that, and I'll just for the record, I'll read the whole thing. So I apologize for being long-winded. It would provide under 10105E4 of the criminal procedure article that a person is not entitled to expungement if, and it would create a new Roman 2. The petition is based on the entry of probation before judgment for a violation of section 21-902A or B of the transportation article, and the person within 15 years after the entry of the probation before judgment has been convicted of a crime other than a minor traffic violation or a crime where the act on which the conviction is based is no longer a crime, or 2, received probation before judgment for a violation of 21-902 of the transportation article, and then would leave the other language intact. There is one place that I would recommend that we make a technical fix to existing law. It just changes the word of to after. I can explain that. Current law says that a person it would be ineligible if they had been convicted of a crime other than a minor traffic violation within 3 years of the entry of probation before judgment. That is technically meant to mean after, because a conviction before your PBJ really wouldn't have any bearing on it. So my recommendation would be to just do conforming language there.
All right, move the amendment. It's been seconded. All right. Everyone's okay adopting the amendment. Now the bill is before you with the amendments. The motion is for favorable
With amendment.
with amendments.
Yeah, I thought we needed B&T on this.
Oh, you're right.
We do.
We do. Oh, no
With the
joy.
amendments.
All right, we're holding the amendment. The bill's complete. We just gotta wait for B&T. Hey, oof. So close.
I forgot about that too.
Hey, so did I actually. All right.
Can you send me?
All right, well, at least the bill's done, okay? The bill's done. We just gotta get. They said this week, they said, it's not just your bill, it's like, I have like 11 bills. It's 11 bills that they said next week they have to finish the budget and then, hey. They're doing good work over there. We'll get it done. All right, well, at least the bill is done. As soon as they give us the bless off, then with all those bills, we'll move forward with them. Okay. So close. All right, we'll now go on to Senate Bill 423. That's Shamari.
Senate Bill 423 requires a county through its designated agent to provide upon request a certificate enumerating what taxes, assessments, and charges are due against a property. The bill would further require a county employee presented with the certificate to endorse a deed and establishes that the endorsement is sufficient authority for a transfer on the assessment books. A bona fide purchaser for value of real property in the county would be entitled to rely on the certificate to establish any tax or assessment due to the county. There is an amendment in your packet. That's Amendment 563926/1. And that amendment makes technical changes to the purpose paragraph, and it requires a collecting agent to endorse a deed as required on payment of all charges in the certificate. It deletes municipality from being required to produce a certificate, and it requires collectors, treasurers, and directors of finance to develop procedures for obtaining these certificates.
Senator James's amendment.
Yes.
Okay. It's right here. I can give it to you when I'm done.
Okay.
All right, discussion on the amendment. Senator James, would you like us to move on? All right. Motion to adopt the amendment. Is everyone okay? All right, now the bill is before you as amended. Further discussion. Motions for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 423 with amendment passes unanimously. We're now going to go on to Senate Bill. We missed over Senate Bill 174? Is that right?
Yes.
All right, let's
That
go
is
to,
another one that's still in B and T.
okay. What is the fiscal note on that one?
It's around 700,000. There were two amendments, one from the chair and one from the sponsor.
Let's go ahead and discuss that because will that curtail the
I think the chair amendment was on the recommendation of the Attorney General, which I believe probably would lower the fiscal note. And the other one has some other, probably, I don't know. I don't want to make a fiscal estimate on it.
let's discuss the two amendments, and so at least if we get the bill in prime shape, and then when BT gives us the blast off, we can just vote it without further discussion. So let's discuss the First Amendment.
So the First Amendment, well, you want me to talk about the bill first? Okay, so Senate Bill 174 extends from 60 to 120 days, the period during which the holder of a non-commercial driver's license may be out of compliance with the child support order before the Child Support Administration is authorized to notify the MVA to begin the process to suspend the obligor's license. So the First Amendment in your packet, that's the chair's amendment. That is Amendment 103924/1. And that amendment allows a court to suspend the privilege if the obligor is 120 days out of compliance with the most recent child support order. And it makes changes to factors a court would consider in deciding whether suspension would be an undue hardship on the obligor. That was an amendment requested by the Attorney General, in part due to the fiscal note, but also in part due to potential loss of federal funding that requires the state of Maryland to have effective procedures for suspending licenses for people that are out of compliance with their child support.
Do you sponsor? Do you have any comments on it? You're fine for. Okay. Are you? I mean, with the Attorney General, you're okay with it?
There were some differences between.
Okay, you did. Okay.
I think mostly in terms of the process that the court would have to go through, which I think was affecting the fiscal note.
Okay. So let's move this amendment. Is everyone okay? All right. Now, I don't know what this other amendment does.
So I can. I'm sorry.
Senate Bill 139, very similar. Chris? Senate Bill 139, I got a note here, merging it with it. Yeah. It's always good to bring up your notes.
So neither of these amendments would merge
Okay.
that bill. And that was, I mean, both the 174 is above the $250,000 limit. And the fiscal note in 139 is
BNT. Well,
it's significant. So I think that the decision was made to keep these two separate for now.
you think that's what was the decision? Keep them separate? Okay. Did you hear that, Chris? Okay.
Sure, sorry. So the sponsor amendment deletes the provision about a randomized lottery that's in the original bill. There was a letter of information from DHS saying that they've never used a randomized lottery. We heard some testimony about that at the hearing, and so, you know, there was some testimony at the hearing that that the agency will do a randomized lottery when it decides which obligors names to send to the MVA. I mean, according to DHS, they absolutely don't do that, and they don't know where that.
I want to know where
came
that
from.
idea came from, though. That's, yeah. It's your lucky day, you get to pay. Your lucky day, you get to pay. But someone that owes $5,000, you'll pay $5 because you got selected. All right. That's an awesome, great idea. All right.
And so there was a few other things that amendment did. It adds provisions requiring notice of suspension to be served on the obligor. It alters the factors a court considers in finding that suspension is appropriate, and it alters the factors a court considers in determining whether suspension would be an undue hardship.
All right, we already adopted the other amendment, is that right? Okay. So what is the pleasure of the committee? Motions to adopt the amendment? Motions were favorable? Bueller. Second, is everyone okay adopting the amendment? Okay. And now the bill is before you guys amended. Further discussion? Motion is for favorable, it's been seconded.
Oh, wait.
Again. Really? What is the fiscal?
I believe it was around 700,000. And that was based on the original bill, which
You said that, I know that, okay. Yeah, we can't do that, but it's ready though, at least it's ready, and we can't move it pending, we could just, it's ready, so we can just vote it as soon as we get. Is there a way that we could get a reassessment of the bill? From fiscal notes? They don't do revised fiscal notes.
isn't on the third
Is there a way to get any sort of like informal advice? No?
I mean, like,
Okay. Can we do that? I mean, I know,
the agency can rerun their numbers.
is that the agency? I don't know. All right, well, we'll make a request and follow up. But it's pending B&T approval as well. Okay. So now we'll move on to Senate Bill 424. That's Jamie.
Senate Bill 424 expands a limited exception to the hearsay rule in a criminal case applicable in certain cases when a statement is offered against a party who, through wrongdoing, has caused the unavailability of a witness who made a statement, to include cases in which a defendant is charged with assault in the second degree. There are no amendments in your voting packet.
Senator Carter.
I must have been out of the room on the bill hearing because I don't really remember it, but it certainly raises a lot of red flags in my opinion. So I'd like to have sort of a discussion about it. I've been here for a number of years, and to carve out exceptions to hearsay to allow statements to be admitted into court that are in violation of the rule, we have always had very stringent standards. And little by little, we've been chipping away at that. And now, according to this bill, we would do it in a misdemeanor case for second-degree assault. Can you clarify Jamie, the limited instances? Because you stated wrongdoing. I think I know what it intends, but wrongdoing is very broad.
So just sort of from the 10,000 foot view, the court would need to find by a preponderance of the evidence that the party against whom the statement is offered engaged in activities that rendered the witness unavailable. Now, unavailability includes situations in which the declarant is one, exempted by a court ruling of privilege from testifying, two, refuses to testify despite a court order to do so, three, testifies to a lack of memory on the subject matter of the declarant statement, four, is unable to be present or testify because of death or then existing illness or infirmity, or five, is absent from the hearing and the party offering the statement has been unable to procure the declarant's attendance by process or other reasonable means. So that if the defendant had procured that by wrongdoing and the court found it by preponderance of the evidence, any of those five, then that would be the situation.
It's not very specific, but I know that the sponsor wants to speak. Can I just say, or you want to go ahead? I'll say. No, go ahead. I'll save it.
What happened is, actually, the federal system and every state that I could research and the state's attorneys could research, Maryland was really the only state that doesn't include this sort of violent crime in the exception to hearsay that already exists. So this adding second-degree assault to this statute that we have, and we already have a statute that says in any felony case, all of this can happen. So it's really about witness intimidation. So the state's attorneys who deal with domestic violence said, you know, because we have a very antiquated criminal system. So our first degree assault is, I'm not an expert, but has to do with, you know, maybe a firearm and a couple of other things. And our second degree assault is very violent, but for some reason we call it a misdemeanor, and we're the only state that does, and we have a 10-year sentence. So what they were saying is, this is very challenging for them, primarily in domestic violence situations where normally that's what they're prosecuting the fellow for. Yes. Would have to be a second degree. It's a serious
Second degree assault is a wide range. It can be anything from brushing up against somebody to actually punching them to.
Actually, that's not true. You have to have pretty significant injury. If somebody would get me the code, you can look at it, right? So I think third degree assault might be where.
No, that's not.
Brushing up.
I don't want to challenge you, but second degree assault is a very wide range, and we've continued to keep it as a misdemeanor, except for limited exceptions where we made it a felony to conduct it against a police officer, which is a relatively common charge.
Right.
It does not require a significant injury.
But
My point, here's the point. by the preponderance of the evidence standard, which is basically my word against yours. It's a very, the lowest standard that we have in law, preponderance of the evidence. So by a preponderance of the evidence standard, the person indicates that the person did some wrongdoing to me, or no, I'm sorry, the state's attorney represents to the court, I imagine, the state's attorney in an in-camera hearing to argue whether the statement could get in. Which also, actually, it's so multi-layered as I'm thinking it through, because most of these misdemeanor second-degree assaults are not even in a jury trial posture or an in-camera thing, because they're misdemeanors. So we're talking district court. So the state's attorney argues that the statement should come in.
There's a whole process, Senator, about how you have to have a separate hearing. And
I understand, but in district court, because that's felonies, but most of these second-degree assaults are in district court.
look, I don't know.
It's different.
I'm not sure I can debate you on that particular issue, but what I'm telling you is the federal rules already allow this, and every state I could find already allows this. Whenever you intimidate a witness, the rule
But
is.
this isn't a witness intimidation bill, though.
Yes, it is. That's exactly what this is. And
It says wrongdoing.
it is about it's about keeping.
To move
somebody-
things along, I'm just gonna ask
from
if we could
not
hold it. I'll take
hearing
a look
it.
at it, but
No, that's fine.
it sounds like a really awful idea.
No, this is great dialogue.
ahead
This,
and get it.
this is good. Go ahead and read the jury instruction and then we'll put a pin in this, but just for everyone to have, sure.
So,
Second degree assault.
second degree assault can come in a couple of varieties. It doesn't require a battery. It could be a battery. It could also be intent to frighten or an attempt to batter. I think the one that most people are familiar with is battery, so I'll go ahead and read one of the jury instructions for battery. Assault is causing an offensive physical contact to another person. In order to convict the defendant of assault, the state must prove, one, that the defendant caused offensive physical contact with or physical harm to the victim. Two, that the contact was the result of an intentional or reckless act of the defendant and was not accidental. And three, that the contact was not consented to by the victim and not legally justified. Again, I can also read the intent to frighten. So you don't actually need a physical contact at all to have a second degree assault.
Doing that has made a witness unavailable for court.
The problem for a misdemeanor offense, that could even be an offense where there was actually no touching. It's too
Well,
far.
all I'm saying is the Supreme Court has said that this is
Too far.
the law. You should never profit from your wrongdoing. A witness should
No, but you
never.
should, but generally we say that you have to have a standard of beyond a reasonable doubt for wrongdoing. But now we're determining a
Well, this
wrongdoing
is not
under
about.
a minimal
we're not-
standard.
This is reasonable doubt. It has to do with they're going to be convicted of a crime. This is about letting a statement come in
I
to
understand.
court because someone has wrongfully prevented your being there. So that. I'm
But
just
the
telling you that-
assessment, the determination for whether they've prevented you being there is the low standard. So basically, it's just the one word against the other. I'm saying it's a very low standard to do this overreach to this broad category of second degree
We're the
assault,
only state.
which counsel
does
has
it.
just indicated does not even
Right.
necessarily involve a
right.
physical touching.
Excellent. This is
Alright.
good. This is good dialogue.
Good
Got
dialogue.
it. But we're
Love it.
gonna hold it so we can continue the discussion and we'll come back. Well,
I'm fine with that.
okay. Excellent. All right. So now we're gonna go on to excuse me, I want to lock this one in something. Go off to something a little lighter for a second. Let's see, can we go on to Senate Bill 486 and we'll come back up to the top of the list.
Oh, my God. Wow.
Get to that point, the standard here, I'm like. I think y'all aware.
That's awesome.
So things got a little spicy here. Senator Folden is distributing Snickers, so we're all on our best behavior as we continue our voting session. All right.
When you're hungry.
You say yes, yes. All right. Thank you very much, Senator Folden. All right, now we're on to Josh. Let's go on to Senate Bill 486. That was a good respite there. All right.
Senate Bill 486 requires the Maryland Correctional Enterprises Management Council to research the number of private entities that offer goods and services that are also available from the MCE and the average prevailing market prices for those goods and services, to compare the cost of those goods and services available from MCE to the cost of the same goods and services available from private enterprises, to review and comment on the potential benefits of the state soliciting private enterprises to provide those goods and services, and to report to the General Assembly by July 1st, 2026 on their findings.
All right, motions for favorable. It's been seconded. We're gonna do a roll call. I'm sorry. Hold on. Well, 486. We'll take our time. 486.
Vice Chair Striker,
Yes.
Senator Sidnor.
Yes.
Senator West,
Pass.
Senator Muse.
Yeah.
Senator Folden,
Yes.
Senator James,
Yes.
Senator Charles,
Yes.
Senator Kelly,
Yes.
Senator McKay,
Nay.
Senator Carter,
Yes.
Senator West,
Nay.
Chairman Smith.
Yes. Senate Bill 486 passes what? 92. Okay. Bill 470 is being held. Senate Bill 471 is also being held. Senate Bill 479 is being held. The work group. Yep, I'm coming right up to that. 479 is also held because the work group has not had an opportunity to meet. So the last two bills here, we're going to go with Senate Bill 465 and then discuss Senate Bill 452.
Senate Bill 465 establishes standards relating to the installation and use of electric vehicle recharging equipment in cooperative housing corporations. The bill also extends existing procedures related to electric vehicle recharging equipment in condos and homeowners associations to include electric bicycles, and requires the Department of Housing and Community Development to include additional information on its website related to common ownership communities. There's two amendments in your packet. Amendment 1, 843-628-1. And so that amendment is a sponsor amendment, and that would require the installer of charging equipment to get insurance for the electric vehicle charging station before installation. Do you want to adopt or? Mhm. And I can explain the second one. The other amendment, 803-526/1, requires the Department of Housing and Community Development to make available on their website specific information on contractors certified through labor management training programs.
Oh, so just to clarify for the committee, the First Amendment was discussed at the hearing and that got the stakeholders on board. The Second Amendment was the compromise that was reached between Delegate Corman and IBEW on their letter requesting an amendment. So both of those amendments I strongly support. And I guess I'll move the amendments.
Yep.
Okay.
Motion to move the amendments and seconded. Is everyone okay adopting the amendments? Okay, now the bill is before you as amended, and we'll open it up for discussion.
Senator Kelly, can you explain what the bill does exactly?
Love you, Senator Paulden. So
Never mind, I've removed
No,
it out.
it's just co-ops. I will give an update for the committee members because I tasked Chairman Corman over there with making sure it's just co-ops. I wanted him to make sure, since we had that conversation about condos, that he had reached out to all the rural areas. There is one co-op in Garrett. They're fine with it. Allegheny, they haven't heard back from. Washington doesn't care. Frederick doesn't have any, and Hartford doesn't have any that they could find. So he did his due diligence.
Applying those lessons learned early in the session.
Evidently, learn something new every day.
All right, motions for favorable with amendments. Second, is everyone okay being recorded in the affirmative? All right, excellent. Senate Bill 465 with amendments passes unanimously. I'm glad you learned from the lessons in my trials and tribulations. It's been-
Exactly. We can't do 200 victims. That's what I'm always telling you.
I hear that more than anyone. We're just gonna have another Snickers. It's gonna be okay. All right, let's do one more, since we're on these cooperatives. Let's do Senate Bill 510, then we're gonna come back to Senate Bill 452. Senate Bill 510, Josh.
Senate Bill 510 establishes that non-escheat capital credits held by an electric cooperative may not be presumed to be abandoned property and authorizes the use of such non-escheat capital credits by the electric cooperatives for specified purposes.
Discussion? Motions for a favorable. It's been second. Is everyone okay being recorded in the affirmative?
Yes.
All right. Senate Bill 510. Approved unanimously. All right, let's go on to Senate Bill 624.
He wanted to be added on and not hosted, so whatever your pleasure is. Unfortunately, I have to go do my hearing.
Okay, got it. But, okay. They don't want to do it anymore. They don't want to staff it.
They did not want to, but they wanted to be added as a part of the task force, I believe. That was their request.
Interesting. Okay.
Did you not?
Can you staff and? I know. Can you staff and?
It's not true.
Yeah,
I'm sorry, I'm speaking, no, they wanted to be added as a member of the task force. They wanted resources to staff. That's what it was.
they wanted budgeted resources to.
That's the case that came.
Yeah, but I'm not even sure how that, can you take her off? I'm not even sure how that works. We're gonna, yeah, I know. So then that means that, all right, so Senator Jamie, can we go to, or is that, I think that's Shamari, Senate Bill 550.
Sorry, just trying to find it in my notes. Senate Bill 550 adds labor trafficking by a child's parent or guardian to the list of conditions under which a local department of social services is authorized to ask the juvenile court in a child in need of assistance proceeding to find that reasonable efforts to reunify a child with the child's parent or guardian are not required. And two, it expands statutory provisions relating to the Safe Harbor Regional Navigator Grant Program to apply to child victims of labor trafficking.
This motion for favor has been seconded. Do you want to just, can you explain and then just, it's been seconded, so we're loaded, the judiciary's opposition, just real quick.
Sure. So the judiciary thought the definition was different in the criminal law context. They also thought it may be difficult to apply in the parent context, the force, fraud, or coercion requirement for labor trafficking. They said the definition is different in the criminal law context. So the definition part only applies to this section. And so if you look at the bill. So I can explain that part a little bit. So in Maryland, corporal punishment is still legal. And so when applying for fraud, coercion to a parent, you know, if a child gets a spanking because they didn't go to work, is that labor trafficking? It's difficult to marry those concepts, whereas if that's occurring between adults, the spanking is an assault.
And who is attempting to hold certain things over their child's head to force them to do work. So it's not just spanking, it's slowly saying, you know what, if you don't go to work, you're not going to have some place to live. If you don't go to work, I mean, that example that was given certainly is not what this is intended for. So again, I think if the definitions are applicable to two different sections, as I've always said, I mean, the judiciary, I don't know how many times that they actually support anything that we do. So I'm not moved by their comment.
The other issue in the judiciary's issue was the definition of which word, Shamar, of which definition?
Labor
Force?
Trafficking.
Oh, the actual labor trafficking.
Yes.
Okay.
Well, the Maryland Department of Human Services has an amendment can you speak to that? Because they're favorable with amendments and I think they're speaking to this issue. I don't think they've submitted a formal amendment, but they have an example in their testimony. Counsel, if you could read.
So the testimony by the Department of Human Services, it said SB 550 intersects with our Social Services Administration policy, where labor trafficking is defined according to Maryland criminal law as knowingly taking, placing, harboring, persuading, inducing, or enticing another by force, fraud, or coercion to provide services or labor, or receiving a benefit or thing of value from the provision of services or labor by another that was induced by force, fraud, coercion. If passed, SB 55 presents statutory support for implementing SSA CW 23-2. and the policy would be amended to align the definitions.
So I know this is DHS, I mean, if DHS is here, I mean, can you just provide some background on that? If you're. Can you give her the mic?
Thank you. For the record, Rachel Sledge, Director of Government Affairs for DHS. So if you continue in that following paragraph in our testimony, we explain that one of the concerns is that we feel that we need to include by any individual so that we're aligning the definition of sex trafficking with labor trafficking. The concern is that the divergence would then give some exception to individuals who are forcing, frauding, or coercing a child into labor trafficking that isn't also captured in the sex trafficking definition. Is that clear, Shamari? Okay.
Yeah, so can we consider that amendment in concept, or do we need to wait to draft it? Because it's too complicated.
I probably need to look at it and draft it more,
So
just to be sure.
If you're amenable to that, I mean, sorry, okay, so let's draft that amendment and we'll just hold it. It'll be ready for prime time next time we vote.
Thanks, Shamari. Thank you.
thank you.
I was told that the difference of the definition is, I mean, from the criminal context and what's in the bill is the word child. That's the difference.
Get it. Okay, we still got time. So look, next week we're gonna vote once, and then the week after that, we don't have hearings. So we'll have a lot of time to vote before crossover. So we'll be, and that's because, hey, Sandy Pop here, despite being overloaded, has set us up for success. So we've got a lot of decision space at the end of the road here. So just because we're holding a lot of stuff doesn't mean we're not going to get a lot done. It's just. But hey, thank you very much for that, by the way, Rachel. Thank you. Okay. Now let's go on to Senate Bill 607.
Senate Bill 607 authorizes the imposition of summary punishment of a police officer for a minor violation of law enforcement agency rules and regulations if the facts that constitute the minor violation are not in dispute. Summary punishment may not exceed a written reprimand and is not appealable by the police officer. Further, the bill establishes that existing provisions of law relating to police accountability and discipline do not prohibit the summary punishment by higher ranking police officers as designated by the chief, and existing provisions of law relating to police accountability boards, administrative charging committees, and trial boards do not apply to the imposition of summary punishment. There is one amendment in your voting packet from Senator Folden. That is Amendment 673-826/1. The amendment provides that in addition to the bill's other requirements for summary punishment, the officer must agree that the facts are not in dispute and must accept the summary punishment.
All right.
So the purpose of the amendment would be that the minor rule violations would be those that are categorically captured in the disciplinary matrix through MPAA. That matrix is for class A, category A and B violations. Violations go all the way up to an E category. The highest level of discipline that you could get from a B violation is a written reprimand. That is the highest violation. And again, and speaking with counsel, it's important to note that we want to keep these as the violations that do not involve a member of the public. And those violations, we still want that to be able to be forwarded. But these violations that are technical in nature, that are within the department, that they shouldn't have to go up, and summary punishment would apply.
In concept, if it's okay, Senator, I can amend in the language about not involving a member of the public. If that works for you.
Yep.
All right, so we want to move the amendment. Seconded. Is everyone okay? Adopt the amendment. All right, now the bill's before you as amended. Further discussion? Motions for favorable with amendment? It's been seconded. Is everyone okay being recorded in the affirmative? Okay, excellent. Let's go down real quick. Let's keep Senator, this is Shamari, SJ1.
This joint resolution states the General Assembly's opinion that the Equal Rights Amendment meets the requirements of Article 5 of the U.S. Constitution and should be recognized as the 28th Amendment. It urges the administration of Joseph R. Biden to publish without delay the Equal Rights Amendment as the 28th Amendment to the United States Constitution. It urges the United States Congress to pass a joint resolution affirming their Equal Rights Amendment as the 28th Amendment and calls on other states to pass similar resolutions.
So on the first day of Women's History Month today, I would implore upon my committee colleagues to just let us pass this out. It is the top priority of the Women's Caucus. It is a simple resolution. I know that people think that resolutions are silly, but I think this is meaningful for a lot of people in our communities. And I will remind the committee that in 1972, Maryland voters already affirmed Equal Rights Amendment to the state constitution. So move the resolution, I guess.
James,
Sponsor amendment, am I on that bill now?
we can do it right now.
Okay.
Okay, thanks. Yes, I'd like to make a sponsor.
All right,
I know I did it. during
I'll
the hearing.
be out there. I'll jump on as
Yeah.
well. Senator Charles will jump on as well. Senator Waltz-Riker will jump on. Senator Sidnor will jump on. Okay, now Senator West has a question.
Not a question. I just wanted to say, can I speak on the bill? Yeah, there's no amendment pending. I love the sponsor of the bill, and I love the enthusiasm with which she proposes this bill. On the other hand, I think it's a really bad idea for the General Assembly of Maryland to pass resolutions giving legal advice to the Supreme Court, which is what this does. And if we start down this road, heavens knows how many progressive positions on issues coming before the Supreme Court we will want to weigh in on and give legal advice to the Supreme Court, which they will never read and will never take, and will be far better expressed in amicus briefs before the court than in resolutions passed by the Maryland General Assembly.
Oh, I just want, and you know, I respect you, but I gotta take issue with one thing. There's nothing progressive about this. This is about fairness. Right? This is about 50% of the population. This is about an inexcusable mistake at the founding of our country, that we are not protected in the Constitution as men are. So I just, whatever else you think about this amendment or the ERA or even how this resolution, I don't even think you meant to say progressive. It's manifestly fair from the beginning. Thank you.
So let me withdraw the adjective progressive. The rest of what I said still stands.
We need more Snickers at voting sessions. No, right, all right. So there's a motion, so it's been amended. We've had sponsor amendments adopted. The bill's before you with the amendment. The motions were favorable with amendments. It's been seconded. Do we need a roll call?
Yes.
Okay, roll call.
Vice Chair Waldstreicher,
Yes, and Chair, if I could just briefly give a quick shout out to our good friends at WDC Women's Democratic Club who've been pushing this, and in particular, President Tazeen Ahmad, who was so instrumental to this. Thank you to them, and I'm a yes.
Senator Sidnor,
Yes.
Senator West,
No.
Senator Muse,
Yes.
Senator Folden,
Yes.
Senator James,
Oh, yes.
Senator Charles,
Yes.
Senator Kelly,
Yes.
Senator McKay,
Yes.
Chairman Smith.
Yes. All right. Excellent work. We're now going to go on to Senate Bill Shamari, Senate Bill 668.
Senate Bill 668 requires the Department of Human Services to provide new luggage to a child in foster care who is being removed from a household. By December 1st each year, DHS must report to the General Assembly on the number of instances in which a disposable bag was used to transport the personal belongings of a child in foster care and the reason DHS failed to provide the child with new luggage, and 2, the supply and inventory management procedures for the new luggage supply. DHS may solicit and accept gifts, grants, and donations of any kind and from any source to carry out the bill. There is an amendment. This was proposed by DHS, and it requires the department to provide luggage to children entering, moving placement, and exiting foster care as opposed to just being removed from a household. And it requires the department to have age and mobility appropriate luggage, and it forbids the department from using disposable bags or trash bags.
Yeah, we accepted that as a friendly amendment to the bill after speaking with the agency. And so looking forward to making sure this is not an issue for any other child in the state of Maryland. So this is a great bill. And I thank all of you all for supporting it.
Thank you. And now bring it to
It's a good way to end the week. So let's adopt the amendment. Is everyone okay with adopting the amendment? Is everyone okay? All right, now the bill is before you as amended. The motion is for a favorable with amendment. Is everyone okay being recorded in the affirmative?
Yes.
Thanks. Okay. Oh, wait, you want, so are we reconsidering the vote so we can do another amendment on there? Is that what happened? Okay, everyone wants, the entire committee wants to be on the amendment, so.
Except for Senator Carter, because she's not here.
Yeah.
Everybody?
All right. I almost don't want to let the moment pass, but we'll, you being, you're,
Just shut down voting.
yeah, that's a good, sure. Senator James.
On the bills that you're holding, I hope that whatever they're being held for, including my own bill, that the people that want them held will look at them. I see the person isn't in the room, will look at it so that, there's not an indefinite hold that it can be looked at and revisited, and they can watch the video and read the testimony in support of the bills that they didn't weren't here for.
Right, actually, this sounds like a good time to, and, well, Senator Charles, I want to take a run at these last two for you, and then we'll close up. But for the bills that have been held, that's why we kind of advanced a number of them so that they're at least sound, so that when they get consideration from budget and tax, that we'll be ready to go. But for the other ones that members have concerns of, we're going to review and set up work groups on Monday so that we're ready to go by Friday.
Thank you.
Okay, then Shamari, I think you have the next two, right? So 669. And I know we have 669, go ahead.
Senate Bill 669 repeals the requirement that the Attorney General by December 1st of each year report to the Governor, the Legislative Policy Committee on any action taken under the Maryland Defense Act regarding the investigation, prosecution, or defense against any action or inaction by the federal government that threatens the public interest and welfare of the state's residents as specified. The bill also repeals the requirement that the Attorney General annually publish its annual report and opinions from the preceding year in a bound volume. Instead, OAG must publish the specified reports on its website. There is an amendment, and that's amendments 433-928/1. And that bill would delete the modification of the reporting requirements under the Maryland Defense Act. And so that just strikes that portion from the bill, but it still would be current law.
Shamari, does that mean that goes back to the December 1st, that it has to be updated annually by December 1st? Or is there no date?
They still have to report as required under current law, their activities under the Maryland Defense Act.
So it would go back to them having to have this published annually by December 1st? Because that was the part that was bracketed out.
Right. It goes back to that.
So it removes the brackets
removes the
and leaves the
brackets.
date back in place.
Yes.
Thank you.
Yep, it's friendly amendments again. This was brought forth by the Attorney General's office, who is a good person to our state. And so this is something that's going to truly help their office effectively. And my good friend, Senator Foden, offered another amendment. So it's a friendly bill, friendly amendment, so we can move forward on it. And I ask everyone to accept the amendments and the bill as amended.
All right, so we're gonna on amendment 213-020/1. Motions to adopt the amendment. Everyone's okay? All right. Now the bill's before you as amended. This motion open for discussion. Motions were favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Excellent. All right, we're now going on to Senate Bill 672. It's the last bill that we gotta go.
Well, can we do 1051, 1051?
Withdraw. Oh yeah, we'll do that, and then I gotta get over. Senate Bill 672.
That's Josh.
Senate Bill 672 requires that citations and notices issued as a result of automated enforcement under the vehicle law be sent to the current mailing address or residential address on file with the MVA.
Motions were favorable and seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 672 passes unanimously. Is everyone okay calling it right now?
We do.
Oh,
Yeah,
all
I
right,
think
sorry.
we should do 688 and you should
Oh,
do
okay,
100.
all right, all right, couple more bills. And then, all right, we'll do, all right, keep rolling. Senate Bill 668. 688, my apologies, 688. We just did
That's-
668.
That's another bill that needs approval of B&T because it's a 366,000 fiscal impact.
Motions for favorable, unfavorable, withdrawn on Senate Bill. Okay, it's been seconded. Or we get recorded from. Senate Bill 1050. All right. Then, Senate Bill 608 will.
Senate Bill 608 requires a law enforcement agency to file any administrative charges arising out of an investigation of alleged police officer misconduct that is not required to be reviewed by an administrative charging committee within 1 year and 1 day from the date of the incident that led to the investigation. However, if alleged police officer misconduct is related to activity that reasonably appears to be the subject of a criminal investigation, an administrative charging committee or a law enforcement agency must file any administrative charges within 1 year and 1 day of the date of either the investigating law enforcement agency's determination that the matter is not related to criminal activity, the final disposition of all related criminal charges, or finally, the administrative charging committees or law enforcement agencies' receipt of a notice that the appropriate prosecutorial authority declined to file criminal charges. There is one amendment in your voting packet from Senator Folden. That is Amendment 833, 827/1. The amendment requires that charges be filed 1 year and 1 day after a law enforcement agency becomes aware of an incident rather than from the date of the incident.
All right, go ahead. So Senator Folden.
If we can move the amendment, then I'll talk on the bill real quick, just to give the clarity. I just want to make sure
Okay, and then-
everybody's crystal clear.
And I remember we had a good, yes, so let's move the amendment. Is there okay adopting the amendment? Okay, go ahead. And then I have a question for you as well, because I think we had a discussion.
So I just want to be sure that everybody's clear on this, that this is taking, one of the issues that came out of the MPAA is that they put a finite deadline of a year and a day from the time of the offense. And what's happening is that we're seeing that there may be a potential criminal misconduct. So there's a parallel investigation that's occurring in the state's attorney's office in their integrity units. And there's one occurring by law enforcement, but law enforcement cannot adjudicate their administrative charges prior to a criminal disposition because it could taint the case. It could cause problems. So, and then there's times that the case is not being adjudicated until after the year and a day. Thereby, by the way MPA is written, the accountability measure that we also desperately desire is in writing, not enforceable. It is a problem. So I just want everybody to be aware that that's what this is about. This is about actually putting the proper year and a day in relation to the occurrence of the event. And then if there is a criminal investigation that is happening parallel, that the year and a day does not start until the disposition of said charges are done. And that's or the declination of charges by the state's attorney's office integrity unit is completed. That's all. Thank you.
No, that's great. Senator Sidnor, and then I did want to bring up, because I remember we had actually a productive discussion
Yeah.
on the ACLU had a couple of recommendations that I thought we talked about that were not offensive and actually made sense. So we'll talk a little bit more of that. So
Probably just went where I was going
Okay,
to
yeah.
go, which I was going to ask if we just hold it, but you can go ahead with the conversation.
yeah, so I think we had that conversation. So I'm going to read, and then you tell me which prongs this amendment meets. So set the trigger for the limitations period to be the date on which the agency misconduct came to the attention, which you did. Okay. Apply the tolling provision to both subsection C cases involving civilian complaints as well as subsection D cases. Okay. Is that right? Okay. And then amend the tolling provision to include excessive force cases in addition to potentially criminal cases, again, just as prior to LEOBR did.
Yeah, I mean, it's the same thing that's in there. I mean, it's just giving greater clarity. If there's already excessive force, then this encapsulates that. But if you want to make it clearer, then that's fine. But the way this is written, because it's excessive force would deal with an adjudication in a court, then once that integrity unit by the state's attorney's office, which is section E, paragraph 3, which be the receipt of the appropriate prosecutorial authority declining the charge or filing charges, which then would put it into the subparagraph 2 of the final disposition of all related criminal charges. So it's captured in the article, in the language already. But if you want to make it even more clear, that's fine with me. But it's the way it's written, it captures both those situations. The one about from the date of the one from the date of the agency becoming made aware of it is one that actually is substantive and meaningful. The other two are already in the language. I mean, they really are. I think when we start trying to get off and deviate too much into it, we create too much opportunity for interpretation. When leaving it this way, it's very clear.
No, it's important just because I know it, actually you all were simpatico on this, so I just want to make.
Yeah,
sure.
yeah, absolutely.
So,
I mean, Jamie, do you read it the same way on that subparagraph 2 and 3?
Looking through,
It's
the
section-
recommendation, I would agree that the amendment does address concern 1 from ACLU, which was the trigger being the discovery, not the event itself.
Yep.
Let's see, their second is apply the tolling provision to both C and D cases. I mean, there is a tolling provision in
It's already that, yeah.
1 year and a day. Well, C would be, I assume what they're saying is subsection C on page 2, the process of review by investigating unit through the disposition by the administrative charging committee shall be completed 1 year and a day after the filing of a complaint by a citizen.
That's already in. I mean, that's what we just did on the amendment.
Sure.
That's when the agency becomes aware of the infraction. So that's already included in the amendment.
And finally, amend the tolling provision to include excessive force cases in addition to potentially criminal cases against, again, just as prior LEOBR did.
So
I'm
that
not-
would be captured, in my opinion, those are captured under paragraph E, subsection 3 of the first part, which is once the appropriate prosecutorial authority either declines to file for charges, then the year and a day starts, because the problem that we're having is it's moved everything up. So we need it to be filed at the appropriate time to start the proper investigation by law enforcement. We've really shortened the window on these and they're being missed. And then the last part of your amendment, or that they had in there, was about that the final disposition of all related charges. So either the integrity unit of the state's attorney's office is going to give a disposition. They're either going to charge or not charge. If they don't charge, then it goes back to law enforcement, and that's when the year and a day starts.
Sure. And I think as long as I'm not misinterpreting what Mr. Roca wrote
Right.
in his testimony, I would tend to agree that
Yeah, it's already
either
captured.
it was captured in the bill text or
Yes.
through the amendment.
Yes, I agree.
you hear that, Charles? Because I mean, the thing here is like there's no friction. It's just a matter of getting it right. So I think everyone agrees. Sure. Yeah, of course.
Yes, I just want to hold it just for a moment, make certain I got it. Okay. And I hear you.
So then that's that. So we're gonna hold it, but it's ready to go. Did we adopt the amendment?
No.
No. Did we not?
We did. I didn't comment about the amendment.
Okay.
I think we did unanimously, but okay, so it's ready to go, but
For the bill.
yes. Okay.
I'm on to that. I got to do something.
Are we doing, so Senate Bill 617 is a fiscal hold, is that right? Is that a BNT hold?
Yeah, 617, that's $1 million.
I don't see that, but okay.
It's been a long
Wait, do we hold 624?
Yeah.
No,
Yes.
we didn't.
Yeah, that was held.
Okay.
time.
We get a free,
You held it because you had to lose.
oh, no, I think I think you held it because you've,
Oh, okay. I mean, come on, some things have already been done.
There was evidently a request to add the Attorney General as a member of the task
yeah, but if they're
force.
staffing it and on it, is that what?
Well, I mean, I
don't
don't
mean-
think that that's unheard of, but
Okay.
Work it out later. Let's go on.
I say too.
Get this still on the road. Let's get it done
What is so they want to be added on?
as a member.
Okay. And then
I'm not gonna say they don't want to staff it. They just want to make sure that they had the resources. And I think that they actually indicated they were getting them from, do you have any intel on that, Jamie?
I don't think I have any information on that.
Well, if they want to be on it, clearly they're interested, so they can, they can figure it out. There's no opposition, right? Let's just get it done.
The bill says that they shall provide staff.
Right, but well, no, what was told to me was that it wasn't, that they were, and you all have heard this in other bills, they were given a great many task force with no additional resources, but it is my understanding, as you have already probably heard, that we have created more resources for them to staff these task forces, so it should not be an issue. That was just, so the amendment that was requested by the Attorney General was to be added as a member. They did not ask me or ask to not staff it. They just had the concern about the resources, which you probably have already heard on the other bills. This General Assembly is providing them with more resources for staffing these things.
From DLS, I think that was another member of the committee had raised that as a concern from the Attorney General's office. I don't think that I had directly heard either of those things.
I definitely heard that we were putting something in place to give them more resources to staff these task force, not just this task force. They have a myriad of task forces that they weren't able to really staff over the last number of years.
Okay, so Senator Kelly.
Oh, I think I'm kind of echoing what Senator Carter was saying. I think that officially we've heard they want to be added. I think we should add them, and then I think we should pass the bill, and that's sort of consistent with what we've done. There's no, right, we're not gonna add in language saying they need X amount of money, right? It'll all work out.
So, all right, here's the thing. So Baltimore, so let's do this. I would tell you, like, I would swap.
An advocacy group that has firsthand knowledge, and they've filed requests, and they've actually had a whole court case on it. My concern is we need actual people that are making these requests, so that we can understand from their point of view, and they can add to the intelligence.
With the
They're already in there.
It's
not law yet.
What's that?
It's not law yet.
They were in there before.
They're actively litigating against the party that is staffing the task force.
I don't know that they are. Do you know that there's an open pending court case?
But the Attorney General is going to have to defend the state.
We hold this until we get answers to that. Because that's way too important.
Well, you can fix it right now by just swapping the two.
Is there still another member or other organizations that, I mean, honestly, you can't just not have the organizations that are making these requests on the task force. But it's a task force, so people that are on opposite sides of the equation can come together and come to a happy medium. You can't just have one side of the equation. Well, that would be up to the chair.
Let's go. That's enough.
This may not be a good time yet, but I was gonna ask about the Wald Striker amendment to.
We gotta add that on there too.
I mean, this is a statewide bill, so why are we doing something like bringing in, honestly, in fairness, the Baltimore, if there even is a potential of the Baltimore legal action team having pending legislation, why would we bring that in there? Like this is
already in the original bill, and honestly.
Correct, but what I'm saying, it's a statewide bill though, Senator.
As I recall, there was a lot of consternation about various impacted groups. And this committee had issues with a number of them. And I think these came up as the choice by process of elimination. So my point is, if you don't want them on there, as long as there's a fair balance, that should be what we should be seeking, so that we get the full picture.
I think
they are one party, Mr. Vice President, Chair, Vice President. They are one party. That's one. Against what other groups are on there?
Information Act request. I would put them on that, put them on that.
Yeah,
Good.
put them on there.
Yeah. Yeah, you vote.
I think it should be the Attorney General's office because they're the impartial source of oversight. So I would urge and respectfully ask that it be a member of the AG's office because it already requests them to staff it, and there's enough transparency and dialogue with them on this. But it's a statewide bill. We should have the statewide stakeholders that are having affected in each county municipality, those people answering the questions, and the AG can not only be a part of that, but can monitor those transactions and the information coming in.
I agree.
I don't disagree about adding the Attorney General's office, but what I would do is speak up for what Senator Carter is noting. Again, when you look at most of these organizations, they're state actors. I mean, I know they're organizations, but many of them are state actors. I don't know about you all, but I know when I've tried to use the Public Information Act, I think many a times that law is used as a sword to fend off sharing information. I think it would be extremely helpful to have an organization that essentially is looking out for the people rather than the government to be on this committee to speak to their experiences. So with that, I mean, I think if there is some issue with line 7 on page 2, I would make a motion to substitute that and put the ACLU on, which is a statewide organization.
Yeah, I mean, that, and also just to be clear, to the Maryland, the Delaware, and the District of Columbia Press Association are also represented. So it's 3 other people that are representing the people, not the government. So it's, I mean, there's more counterbalance there. All right, so I would do that over the AG and you could swap the ACLU for the org that's represented on line 7.
7. Yeah, said oh, so you're adding 2. Right?
The Attorney General and ACLU. Yeah. You're just replacing one. No, taken off the, correct.
And then we're adding an extra.
No, not extra. Yeah, and we're adding an extra. Yes, the AG. Yes.
Yeah.
Correct. Yes.
Favorable on the chairs and that.
Second.
Right. And then also we've got the amendment for that we've been doing, the task force language amendment. Is everyone okay with that? Okay. Now the bill's before you guys. All right. It's great. All right. The bill passes unanimously. Okay. All right. Have a good weekend. Have a good weekend. Oh, wait. Before we leave, Preacher, Senator Muse, I was gonna wait till we did to do this on when we opened up our hearings, but wanted to just acknowledge publicly our trooper, Trooper Kelly. Yeah, thank you so much. Your calm kept us calm, so I as the Senate President said, we never felt like we were in danger, so it was good. So I appreciate it. Thank you.